Hi and welcome. Today we will study about annual return. Annual return, the name itself says that it contains the various events that are occurred in an financial year with respect to a company. So annual return here is discussed from section 92 to section 94. The provisions of preparation and filing of annual return of a company are contained basically in section 92. This section is particularly important from the compliance point of view. So it is important from the compliance point of view since this is an annual compliance and essentially captures all the important events that have taken place in the company during the financial year. Every company is required to file with ROC the annual return. Every company, whether it is a public company or a private company, is required to file with the ROC the annual return as prescribed in section 92. So what it contains, this is the major topic. The particulars contained in the annual return to be filed by every company are as follows. A question may likely to be asked is, what do you understand by annual return? What are the particulars that contained in an annual return? So there are about 10 points that are given here. So these all things are contained in annual return. So the first point is that the details of its registered office, the particulars of business activities, and particulars of holding and subsidiary and associated companies will be in the first will be the first aspect. So the second particulars contained in an annual report which has to be filed by every company with the register of companies is its shares and debentures and other securities and shareholding pattern. So this point number 2 information is available in balance sheet under the liabilities. And its indebtedness, which mean to say its external borrowings, its external borrowings, its debts. The fourth aspect which contained in the annual return is its members, debenture holders, along with the changes therein since the close of the previous financial year. So the details of the members and debenture holders along with any changes with respect to the people who are joining the company and who are leaving the company, all this information is also available. And the fifth aspect is who are its promoters and who are the directors of the company and who are the key managerial persons of the company along with the changes therein since the close of the previous financial year. And sixth aspect that contained in the annual return, meetings of members. Meetings of members means annual general meetings, how many meetings were held, and extraordinary general meetings, that is a class thereof. And extraordinary general meetings are also the meetings of members only. and board of directors meetings, which has to take place once in a quarter at least, or a minimum of four in an financial year. These details are also should be furnished. Remuneration of directors and key managerial persons, penalty or punishment imposed on the company, its directors or officers, or and details of compounding of offences and appeals made against such penalty or punishments. The ninth aspect deals with matters relating to certification of compliances and disclosures. The annual return, the last aspect is that details in respect of shares held by or on behalf of foreign institutional investors, including their names, addresses, countries of incorporation, registration, and a percentage of shareholding by them. So these are the major particulars that will be contained in an annual return. So signing of annual return and certification in case of a listed companies. So the section 92 provides for certification of annual return by a company secretary in practice. Annual return should be certified by a company secretary in practice. And as per Rule 11 of Companies Rules 14, every company shall prepare its annual return, and in respect of the specified listed companies, the annual return shall be certified by a company secretary in practice, and the certificate will be in the form of MGT 8. In this context, a company secretary in practice who signs the annual return cannot certify the same. Although there is no specific provision prohibiting this, it will not be a proper compliance for the same professional to sign as well as certify the document. So here the point is very clear. The company secretary in practice who signs the annual return cannot certify the same. So which mean to say that, for example, if there is a company and who is who is signing the annual return cannot certify. So hence sometimes although there is no specific provision prohibiting this, it will not be proper compliance for the same professional to sign as well as certify the document. If it is two different people, company secretary who is who can sign it, and it should be certified by a professional who is in practice instead of in employment, then there will be two different people. One is signing and the other one is certifying. That will look to be more appropriate. And penalty for contravention. So this if any company fails to file its annual return before the expiry of the specified period, such company and its officers who is in default shall be liable to a penalty of 50,000 rupees, and in case of continuing failure, with a further penalty of 100 rupees for each day during such failure continues, and subject to maximum of 5 lakh rupees. If company secretary in practice certifies annual return otherwise than in accordance with this section, the rules made thereunder, he shall be punishable with a fine which shall not be less than rupees 50,000 but which may extend to rupees 5 lakhs also. Rule 14 of Companies Rules 2014 relates to inspection of annual returns, whereas the Rule 15 deals with preservation of annual returns. And copies of annual return along with a copy of certificates and the documents required to be annexed thereto shall be preserved for a period of 8 years from the date of filing of annual return. So this is with respect to preservation of the annual returns of a company. Right, the next important topic is prerequisites of a meeting. So the rest of the chapter entirely deals with whatever the few important topics given here. So we are now by and large is going to learn about the various kinds of meetings and the prerequisites of a meeting. So there is a due procedure. There is a due procedure for conducting or calling and convening a meeting. So meetings can be of a general meeting or extraordinary general meeting or a board meeting. So whatever the meeting is, the way it has to be conducted, the etiquettes which are to be followed will remain the same, but technically certain compliances will differ from one kind of meeting to the another kind of meeting. So let us take a turn and swat the terms which are important to know for convening the meeting. So for convening any kind of meeting, it will start with a notice. A notice in order to call, conduct and convening a meeting. The first step in that direction is to give a notice of meeting to the concerned persons to participate. Right. And explanatory statement to be annexed with notice. Explanatory statement means here the meeting why it is being called for should be detailed in that. Right. So all these notice aspects will come into picture before the meeting is commenced. Say for example, if a meeting is scheduled on 1st of November and the notice of meeting should be given in the October month itself by the company to the shareholders and the other persons in case of a general meeting and to the directors in case of a board meeting, and also the notice should be given along with a details of the meeting which is given as an explanatory statement. So once the meeting is called for by issuing a notice, the next step is that conduct of a meeting. While for conducting the meeting, there are certain prerequisites which are to be kept in mind. So dear students, we will be studying here about the quorum and we will be studying about the chairman of the meeting and we will be studying about the proxies. Who are the proxies and what are their rights in the meeting if they are being appointed, and the voting. What are the kinds of voting that can be allowed in case of different kinds of meetings? What are the rules and regulations governing the voting procedure in different kinds of meetings? And after the voting, the resolutions. What are the kinds of resolutions that will be put up in a meeting in order to get approved by the persons who attended for that particular meeting? So one is the during the meeting quorum means the minimum number of members, the minimum number of members required for transacting a business in a meeting is called quorum. So for every meeting there should be a chairman in order to conduct the proceedings of the meeting, and in order to ensure the business that is mentioned in the agenda are to be followed in a orderly manner when the chairman is presiding the meeting. And if the members are not able to attend the meeting, they can nominate proxies on their behalf to attend and vote in case of their inability to attend. And voting how it can be carried out, whether it is through electronic mode or whether it is through the mode of show of hands or ballot box, etc. What are the procedural aspects which are to be complied with? So with regard to voting, we will study. And the resolutions, in case of a special resolution, what is to be done? In case of a ordinary resolution, what are the prerequisites will be studied under the resolutions. So the five major topics under this is quorum, chairman, proxies, voting, and resolution. And once the resolution is passed, the next job is minutes, preparation of minutes of the meeting. So the agenda once put to vote, the minutes will be recorded. Once the members approves the agenda items, it will be minuted after the meeting. It is after the meeting. And maintenance and inspection of documents, and various documents are to be maintained, like register of minutes and procedure for allowing the persons to inspect the minutes book. All these aspects will be carried out post meeting. Post meeting means after the meeting. So these are the various aspects and the prerequisites of a meeting which you are going to study in the entire chapter 7 of module 1. So this is a very important topics, and you may get definitely a question either on notice or quorum or about chairman, proxies, voting, resolutions, and minutes. And definitely there will be 2 to 3 questions every time in your examinations out of these topics only. So students have to be very attentive with respect to each topic, either regarding notice or quorum or chairman or proxies, voting or resolutions, and finally the meeting minutes. Right, now we will go to the first topic. So notice of a meeting is given in section 101 of the Companies Act. So here the point students have to remember is length of notice. Length of notice means not the paper which is to be given to the persons. The length of notice for calling a meeting is the number of days prior to the date of meeting to serve a notice to its members. So it states that in order to properly call, see here, properly call a general meeting, the notice should be sent at least 21 clear days. 21 clear days before the meeting to all the members, legal representatives of any deceased member, or the assignees of insolvent members, the auditors and the directors in writing or electronic mode or other prescribed mode. So 21 clear days is the point student have to remember. This is the length of notice to call a general meeting properly. What is the length of notice? 21 clear days before the meeting. 21 clear days before the meeting. To whom it is to be served? To all the members of the company. To all the members of the company. If there is any deceased member, means who is no more, and in such a case, to his legal representative the notice should go, or in case if any member becomes an insolvent, to his assignee the notice should go, and the auditors and directors normally are to be allowed to participate, and they should also be given notice with 21 clear days. 21 understand. So the notice can be given in either in the form of writing, write on a paper, write it on the paper and signed by the secretary or the director, whoever is empowered, or it can be sent through an electronic mode or any other prescribed mode. So the mode of sending the notice as per rule 18, electronic mode has been statutorily recognized by the Act. Electronic mode, when the time is changing, we also have to change. So electronic mode is the recognized mode, and which is the statutory mode as well for sending the notice. The said rule mentions that a notice may be sent through email as a text. As a text means typing it on the mail, or as an attachment to email, or as a notification providing electronic link and uniform resource locator for accessing such notice. So any these are the mode of sending is the electronic mode as per rule 18. This is the point student have to remember. It can be either through text or through PDF or through a notification where a link is generated. The same link will be forwarded to all the members to access the information. Right. The length of the notice, we know that it is 21 clear days. A company cannot curtail by its articles of association the requirement of 21 days. And now, who is entitled to receive the notice of general meeting? You already know. One is the members and other one is legal representatives of deceased member who is no more, and assignee of the insolvent member. Those who are insolvent, for the property is not with them and it is with the assignee. So assignee will be given a notice to participate in the general meeting of the company. Auditor of the company, because being the statutory auditor, whoever is there, he should be there in the general meeting, and his involvement will be there in case of all the general meetings, apart from the directors who are there for running the company. Right, this is about the participation of people. So the contents of the notice, what is to be there in the notice? Now you know the notice, the length of notice, and the persons to whom the notice is to be given. And now you will be coming to know what are the contents of the notice, right? So a valid notice, to call a notice which as a valid notice, it must state the day on which the meeting is to be held, the date on which the meeting is to be held, hour of the meeting, and place of the meeting shall contain a statement of business to be, and also shall contain a statement of business, means agenda to be transacted in that meeting. It must be issued in the authority of the board of directors under the name of an authorized official. So contents of the notice. So dear students, you might have seen a wedding card. Wedding card is also in like a notice to our relatives to participate in the function and to bless the couple. What is to be there in that, on which day the marriage is, and what is the date on which the marriage, and the time at which the muhurtam is being fixed, and the place where the function is being celebrated, right? And apart from that, what is the time of lunch and other proceedings will also be mentioned, right? So then only it is called as a proper invitation. In the same way, for giving a notice to the members to participate in a general meeting, it should be a valid notice. It must state the day, date, hour, and place, and about the statement of business to be transacted in that meeting. Statement of business means the agenda, what they are going to discuss. It must be issued on the authority of the board of directors. Who is the authority to issue the notice? The authority is the board of directors under the name of an authorized official. The board of directors will appoint someone as an authorized to issue the notice. Could it be a director or could it be a company secretary? They are allowed to send the notice. No other can give the notice of meeting. Say, for example, if your marriage is there, instead of someone from your family go and invite the relatives, if some unknown person goes and invites them, it cannot be a valid invitation. It cannot be a proper invitation. So, in the same way, to make the this notice as a valid, it should be issued by an authorized official who is being authorized by the board of directors. Only the board of directors has the authority to issue as per the articles of association, right? So students, this is about the contents of the notice. This is about the contents of the notice. And omission to send a notice states the section 101 states that any accidental omission to give notice to or non-receipt of such notice to any member or other person who is entitled to such notice for any meeting shall not invalidate the proceedings of the meeting. If you forget to invite one of your dearest friend for your marriage, it does not invalidate the marriage of that particular family, no. In the same way, if the board forgets to issue a notice to a valid member to participate in that particular meeting by omission, then in such a case, it shall not validate the proceedings of the meeting. Right? You understand the point. This essentially means that the omission must not be designed or deliberate. So the omission must not be pre-planned. The omission must not have any other wrong intentions. Failure to send a notice to a member under a belief that it will not reach him at the address mentioned in the registered members is deliberate and not accidental, even if the belief is based on a mistaken impression. So, the onus is on the company to prove that the omission was not deliberate. The omission was not deliberate, right? So, this is about the contents of the notice. and omission to send a notice under section 1014. Right. So now there should be an explanatory statement to be annexed to notice, no? So the notice should be annexed with an explanatory statement. The explanatory statement will talk about the business to be transacted, whether the company is going to deal with the special business or the ordinary business will be known to the members or the persons who are invited to participate in the meeting only if they look at the explanatory statement which is annexed to the notice. Under section 102 of the Companies Act, it mentions that where any special business is to be transacted at the company's general meeting, where any special business is to be transacted at the company's general meeting, then explanatory statement should be annexed to the notice calling such a general meeting, which must specify certain things. So dear students, you should know what is a special business and what is an ordinary business. You will come to know in future. So whenever the company is going to deal with a special business in the meeting, only in such cases it has to annex an explanatory statement to the notice while inviting the members to participate in the meeting. So ordinary businesses, there are 5 ordinary businesses. Except those 5 ordinary businesses, any business means any kind of transactions that is to be dealt with will be considered as a special business. So here the general statement should be annexed to the notice calling such a general meeting, which must specify the nature of interest or the financial or otherwise, if any, in respect of each items of every director and the manager, every other KMP, and relatives of persons mentioned in 1 and 2, and any other information and facts that may enable members to understand the meaning, scope, and implications of the items of business to take decisions thereon. So for the purpose of understanding what is a special business means, let us understand the types of business. What are the types of businesses that are transacted at the general meetings under the Companies Act 2030? So as per the Act, there are only 2 types of businesses. One is a ordinary business and other one is a special business. So dear students, you have to remember there are four ordinary businesses. Except these 4 businesses, all other businesses will be considered as special businesses. So you will get a question not only here in your CA examination or some other this what are the 4 ordinary businesses for a general meeting is a student is expected to know at every time. So the first one is consideration of financial statements and reports of the boards of directors and auditors is an ordinary business. So this will happen, no consideration of financial statements and the reports, and that is considered as an ordinary business. Second one is a declaration of any dividend. Dividend declaration, whether it is an ordinary business or special business, it is ordinary business. Appointment of directors in the place of those retiring. So if some directors are going out and some are to be replaced in the place those who are retiring, it is an ordinary business. Appointment and fixing of the remuneration of the auditors. Appointment and fixing of the remuneration of the auditors is also an ordinary business under section 102 subsection 2. So students, except these four kinds of businesses, all other businesses will be considered as a special business. In simple words, at the general meeting, all the other businesses except the ones stated above are special businesses. At extraordinary general meeting, every business is transacted. At extraordinary general meeting, every business transacted is a special business. That point you need to remember. So now let us come to quorum. So we discussed about the meeting. What we discussed about the meeting, my dear students, what is meant by a meeting is, and what is the length of the meeting, and to whom the meeting notice is to be given, and what is the business that is to be transacted in the meeting. An annexure to the notice we have discussed, and what it should contain in the notice, like day, date, time, right? Day, date, and place where it is to be transacted. Everything is also we discussed. Apart from that, we also discussed what are the kinds of businesses that will be dealt with. One is ordinary business and other one is a special business. And ordinary businesses are only for adoption of financial statements, declaration of dividend, appointment of directors, appointment and fixing of remuneration of auditors, right? These are the four are the ordinary businesses. Except these four businesses, any kind of business is a special business. And for all the special businesses, there should be a separate annexure about that with details of some other aspects as it is given in the Companies Act. So these points are over. Now we are coming to quorum for meeting. Quorum is also very, very important.